Imagine, for just a second, that you're staring down a highly complex, incredibly high-stakes puzzle.
Yeah.
And we are not talking about, a casual weekend brain teaser here. We are talking about a scenario where deciphering the exact meaning of a single, seemingly ordinary word,
Just one word.
right, just one word, could literally be worth millions or maybe even billions of dollars.
It's wild to think about.
It really is. Welcome to the Deep Dive, everyone. We are thrilled you're joining us today because we are looking at a corner of the legal world that operates exactly like that high-stakes puzzle.
A massive puzzle, and it's
Yeah.
one that plays out entirely behind the closed doors of United States district courts.
Exactly.
Specifically, we're going to be looking at the Markman hearing, which, as anyone following patent litigation probably already knows, is a highly specialized judicial proceeding. It is designed exclusively for claims dealing with patent infringement.
Yeah.
And during this hearing, the judge has one single solitary responsibility: claim construction.
Or claim interpretation, yeah.
Right. The judge has to sit down and meticulously define the exact scope and the exact meaning of the words and phrases written into a patent.
And that definition, it usually ends up defining the entire scope of the patent.
Absolutely.
It swings the momentum totally in favor of the inventor or totally against them. So, our mission for you today in this deep dive is to explore how this single legal choke point really shapes the fate of inventors and corporations everywhere.
Because it really does.
We're going to look at why judges, and specifically not juries, hold all the power in this situation. And we'll trace the really fascinating ripple effects this procedural quirk has on the entire U.S. legal system.
From draining judicial resources all the way to drastically extending the timelines of litigation.
Yeah, it's a huge bottleneck.
It is a procedure that fundamentally alters how innovation is protected and litigated in the United States. I mean, to understand the friction we see in modern patent courts today, you have to look at the massive shift that happened in the mid-90s.
Okay, let's unpack this. The inception of all this drama, it starts with a 1996 Supreme Court case, Markman v. Westview Instruments, Inc.
Which is obviously where we get the name.
Right, which gives the Markman hearing its name. This was the absolute catalyst for the current system we have now.
Yeah, and the tension at the heart of that 1996 case is actually a constitutional one.
Oh, right, the Seventh Amendment.
Exactly. Ordinarily, under the Seventh Amendment, an individual is guaranteed the right to a jury trial in certain circumstances. So the prevailing assumption for a long, long time was that if you had a dispute over a patent, well, a jury of your peers would look at the facts.
Could listen to the experts, look at the diagram.
Right, and then they'd decide who is infringing on what. But the Supreme Court in the Markman case made a massive pivot. They held that interpreting patent claims is actually a matter of law rather than a question of fact for a jury to decide.
But wait, we trust juries with incredibly complex, highly technical matters all the time, don't we?
We do.
We ask them to decide on medical malpractice suits involving obscure surgical procedures or antitrust cases with convoluted market dynamics.
Totally.
So why shouldn't we just trust juries to listen to the patent experts and decide what a technical word means?
Well, the court's reasoning really comes down to treating patents not just as technical descriptions of technology, but as legal contracts.
Ah, the contract analogy.
Yeah. If you look at legal history, contracts have historically been reviewed and interpreted by the courts, not juries. Judges are the ones who parse the fine print of a corporate merger, right? Or a complex real estate agreement.
Because it's about legal boundaries.
Precisely. Because patent language establishes the legal boundaries of a property right, the Supreme Court determined that judges are just far better equipped to address those boundaries. They are trained to parse out the legal language in a way a jury wouldn't be.
So the judge is essentially defining the property lines before the jury is even allowed to decide if someone trespassed.
That is a perfect way to put it, yes.
But that contract analogy, it shifts the entire power dynamic of a trial. The moment judges took the wheel on defining these terms, they ran into a practical nightmare.
Oh, a massive one.
If a judge has the absolute power to determine what a patent's words mean, they need strict rules on what kind of evidence they are allowed to look at.
Right.
A federal judge might be a brilliant legal mind, but they aren't necessarily electrical engineers.
Or biochemists, yeah.
Right. They can't just Google complex semiconductor terms or ask a friend in the industry.
No, they cannot. So in analyzing this patent language, the courts needed a formalized framework for what sources of information they could turn to for guidance. And over time, the courts split the acceptable evidence into two very distinct buckets: intrinsic evidence and extrinsic evidence.
Okay, let's start with intrinsic.
Intrinsic evidence is the core material. It's
Yeah.
the first line of defense, and there are exactly three things that fall into this bucket.
The first one is pretty obvious. It's the patent itself. The actual words written on the page are the single most important source of evidence. The court analyzes these words based on their plain, ordinary meaning, but they also have to look at them specifically in light of the invention itself.
Yes, they're looking for the intended scope of protection based on the text the inventor actually submitted to the government.
So the text is paramount.
The text is paramount. But as we know, words can be flexible. Which brings us to the second piece of intrinsic evidence, the patent specification.
Okay.
This is often referred to in the legal world as the dictionary of a patent.
Yeah, I saw in the sources that there's actually a specific statute demanding the Patent Act, almost like its own dictionary.
Section 112.
Right, 35 U.S.C., Section 112. It basically says you have to describe your invention so fully, so clearly and concisely that anyone skilled in that specific field could read it and immediately know how to make and use the invention.
Exactly. And the underlying logic there is that inventors are allowed to act as their own lexicographers.
They can make up their own definitions.
Basically, yes. If an inventor decides to use a very common word, but gives it a highly specific, unique meaning just for their invention, that dictionary of the patent is where the judge finds that out. The judge looks at the specification right alongside the patent claims to see if the inventor used any terms in a way that is inconsistent with ordinary everyday language.
Which leads directly to the third piece of intrinsic evidence, which is the patent history.
Yes, the paper trail.
Right. This includes every single proceeding and communication that happened prior to the patent actually getting approved. We're talking about the entire back and forth, all the representations the applicant made to the Patent and Trademark Office.
That history is vital because it locks the inventor into their previous claims. It provides the court with a much more in-depth understanding of what the inventor originally intended to protect.
You can't backtrack.
Exactly. If the inventor told the patent examiner during the application process, "My invention specifically does not perform function X just to get the patent approved,"
They cannot turn around years later in a Markman hearing and argue that their patent actually covers function X.
right, they are bound by that history.
Okay, so the judge exhausts the patent, the specification, and the history. Those are the three intrinsic sources. But what happens when the judge looks at all three of those and the technical language is still completely ambiguous?
That is where we shift to the second bucket, extrinsic evidence.
The outside information.
Right. This is outside information, typically taking the form of expert testimony. This is where a litigator brings in a scientist or a specialized industry engineer to sit on the stand and explain what a specific term means in their highly specialized field.
Okay, that makes sense.
But what's fascinating here is the absolute civil war this sparked within the federal circuit courts regarding when or even if you could use this extrinsic evidence.
A civil war over experts.
Yeah, you had different appellate panels applying totally contradictory rules, which created a massive headache for litigators trying to build a case. For example, in a 1996 case called Betronics Corp v. Conceptronic Inc., the court drew a very hard line.
How hard?
They ruled that extrinsic evidence cannot be used at all if the intrinsic evidence is sufficient to resolve the ambiguous claims. Meaning, if the patent and its history solve the puzzle, outside experts are strictly barred from influencing the judge's interpretation.
Honestly, that seems like a solid rule to keep trials efficient and focused on the actual documents.
It does. But then, just 3 years later, in a 1999 case called Pitney Bowes, Inc. v. Hewlett-Packard Company, the same court seemingly fractured its own precedent.
Oh, well.
They determined that judges actually could turn to extrinsic evidence for guidance and background context, even in circumstances where the intrinsic evidence was completely adequate on its own.
You can imagine the chaos this caused for legal strategy.
Total chaos.
Litigators preparing for a Markman hearing had no idea which standard the judge was going to apply. I mean, do we spend hundreds of thousands of dollars retaining industry experts just in case the judge follows the Pitney Bowes flexible approach? Or do we rely entirely on the paper trail, hoping the judge follows the Vetronic strict approach?
It was a huge gamble, and it took years for this procedural nightmare to get sorted out. It wasn't until 2015 that the Supreme Court finally stepped in to settle the debate.
And what was the final rule?
They clarified it simply. In claim construction, judges must use only intrinsic evidence first. They have to exhaust those three intrinsic elements. Only if the claim terms remain genuinely ambiguous after that internal review can they open the door to extrinsic evidence like expert testimony.
Here's where it gets really interesting, though, because figuring out the evidence hierarchy was only half the battle for these courts.
Yep.
Once the district court judge finally makes their decision on what the patent means, the losing side is almost certainly going to appeal it. The stakes are simply too high not to. And the appeals process for Markman hearings turned into an absolute statistical disaster. We need to talk about the reversal problem.
The appellate drama is arguably a most impactful part of this entire system. After the Supreme Court created the Markman hearing in 1996, the Federal Circuit had to figure out what standard of review they were going to use when these patent interpretations were inevitably appealed.
Right.
So in 1998, a case called Cybercourt FAS Tex, Inc. answered that question. The Federal Circuit affirmed that the standard of review would be de novo.
Okay, since our listeners follow the legal space, we know that a de novo standard means the appellate court is giving zero deference to the lower court.
Zero deference.
They aren't looking to see if the trial judge made a reasonable call. They're wiping the slate completely clean and reviewing the claim interpretation completely from scratch.
The appellate judges essentially act as if the lower court's Markman hearing never happened. They don't consider the weeks or months the district court judge spent agonizing over the technical language or listening to the experts. They just start over with the raw materials.
So when the appellate court started wiping the slate clean with this de novo review, what did that actually do to the reversal rates? It must have caused a massive spike in overturned cases.
The statistical fallout was staggering. Before the Markman hearing was established, studies showed that the reversal rate for patent claim construction on appeal was roughly 20.8%.
Okay, but 1 in 5.
Right. But after the Cyber decision entrenched that de novo standard, the reversal rate skyrocketed to 32%. Nearly a third of all patent claim constructions were being thrown out by the higher court.
A 32% reversal rate is mind-blowing. Think about the massive inefficiency that introduces into the corporate world.
It's huge.
You have companies spending tens of millions of dollars on legal fees and district court judges spending vast amounts of their docket time defining these terms, only to have the appellate court bulldoze the entire foundation 1 out of every 3 times.
And it makes settlements nearly impossible because the losing party always assumes they have a 1 in 3 chance of getting a total do-over on appeal. Why settle when the odds of a reversal are that high?
Exactly. It just incentivizes endless appeals.
And the legal system recognized this lack of uniformity was unsustainable. It undermined the entire purpose of having a district judge interpret the claims in the first place. So the Supreme Court had to step in again to fix the mess created by cyber.
This was in 2015, right?
Yes, in 2015, they took up a case called Teva Farms, USA, Inc. v. Sandoz, Inc. The Supreme Court officially reversed the cyber precedent. They did away with the pure de novo standard across the board and created a much more nuanced hybrid standard.
So they forced the appellate courts to finally respect the groundwork laid by the trial judges. How does that hybrid standard actually function when a case goes up for appeal now?
It ties directly back into the evidence rules we discussed earlier. Under the Teva standard, the appellate court still reviews the ultimate interpretation of the patent. But if the district court had to rely on extrinsic evidence, say, they brought in a software engineer to explain a complex algorithm, and the trial judge made secondary factual findings about the credibility of that expert, the appellate court cannot just ignore that anymore.
They have to respect the trial judge's assessment of the expert.
Right. They must defer to the lower court's factual findings regarding that extrinsic evidence unless there is a clear error.
So the appellate judges can't just substitute their own opinions on whether an expert was believable. If the trial judge looked the expert in the eye and deemed their testimony credible and foundational to the patent's meaning, the higher court has to accept that, unless the trial judge made an obvious, undeniable mistake.
Exactly. That requirement to defer to secondary factual findings injects a crucial layer of stability. In theory, it should bring that 32% reversal rate down and give litigants much more confidence in the district court's initial Markman ruling.
Though I imagine the long-term statistical impact of Teva is still being analyzed by legal scholars.
Oh, absolutely. It takes years for these trends to fully crystallize in the data.
Okay, so we have covered who is making the decision, the strict rules on what evidence they can use, and how the appellate courts handle the fallout. But there is one final massive piece to this procedural puzzle: timing.
Timing is everything.
If judges have all this power to define the boundaries of a patent, when do they actually drop the gavel on these definitions during the lifespan of a lawsuit?
This is where the procedural ambiguity of the Federal Circuit really shines? The short answer is whenever the individual trial judge feels like it.
Really? No set schedule.
None. The Federal Circuit has pointedly refused to provide strict rules or deadlines to the lower courts on when a Markman hearing must occur. There are implied preferences, but ultimately it is entirely at the discretion of the district judge managing the docket. Generally, we see judges choosing one of three main phases in litigation to hold the hearing.
Okay, so if a judge has the flexibility to do this whenever they want, wouldn't they just want to get it out of the way immediately? Like right at the start of the lawsuit during pre-discovery, before either side has spent millions digging through each other's hard drives?
It seems logical.
It seems like doing it early would force quick settlements, decrease corporate costs, and centralize all the future discoveries strictly around the court's official interpretation of the patent.
The early intervention approach sounds incredibly efficient on paper, but litigators will tell you it is often a disaster in practice. The fatal flaw of holding a Markman hearing during pre-discovery is the lack of context.
Because they haven't seen the evidence yet.
Right. The discovery phase has barely started, meaning the judge is being asked to interpret highly complex, abstract claim language in a complete vacuum. They don't have the full picture of the accused product or the broader market context yet.
They're flying blind.
Exactly. What inevitably happens is that the court makes an early interpretation, but as millions of pages of documents are unearthed during discovery, that initial interpretation proves unworkable or incomplete. The judge then has to engage in rolling claim construction, constantly tweaking the definitions as the case goes on, which defeats the whole purpose of doing it early.
That makes perfect sense. You can't draw the property lines if you haven't even surveyed the land yet.
Great way to phrase it.
That pushes us to the second timing option. Summary judgment. This happens prior to the actual trial, but crucially, after the massive discovery process has been completed.
Yes. Conducting the hearing at the summary judgment stage is the most widely adopted route by federal judges. It strikes the best balance.
It's the Goldilocks zone.
Pretty much. It allows the judge to utilize all the technical context and information gathered during the long discovery phase to accurately interpret the claim. It also helps identify exactly which claims are truly central to the dispute, allowing the judge to potentially dismiss the case right there before wasting weeks of the court's time with a full jury trial.
But doing it at summary judgment still carries that historical shadow we talked about. For years, if a judge conducted a Markman hearing at summary judgment and dismissed the case based on their interpretation, it carried that massive 32% risk of a de novo reversal on appeal.
It was a very real fear.
The new clear error standard from the Teva case adds some protection, but the institutional memory of those high reversal rates still makes summary judgment a high anxiety moment for corporate legal teams.
The anxiety is definitely still there, which leads some judges to choose the third and final option. Holding the Markman hearing at or after the trial itself, right before the judge gives the jury their final instructions.
Waiting until the trial's almost over to tell everyone what the patent actually means feels like the ultimate legal procrastination. It sounds incredibly messy.
It does seem counterintuitive, but from a judge's perspective, there are strong advantages. If a judge waits until the trial phase, they have absorbed all the necessary background information. They have a deep understanding of the specific technology at issue, and they have personally heard all the competing evidence presented by both sides over weeks of testimony.
So they are fully educated on the topic.
Right. They are in the best possible position to make a fully informed, bulletproof decision on what the claims mean.
But the logistical cons of waiting that long are severe. You have a jury sitting in a box for weeks, listening to highly technical evidence and expert testimony without actually knowing the court's official legal construction of the patent they are evaluating.
It's a huge burden on the jury.
Furthermore, it sparks endless, unnecessary litigation arguments during the trial itself because both legal teams are still arguing about competing claim interpretations in front of the jury. It just turns the courtroom into a chaotic theater.
It creates significant friction during the trial. That is exactly why summary judgment remains the preferred middle ground, despite the reversal risks. But looking at all three of these timing options, it really highlights how the insertion of this single judge-only hearing completely disrupts the traditional flow of a lawsuit.
So what does this all mean when we zoom out and look at the whole picture, the 1996 Supreme Court pivot, the battles over intrinsic versus extrinsic evidence, the wild reversal rates, and the timing chaos? And what is the ultimate real-world impact of the Markman hearing for inventors and the legal system?
The most profound consequence is that the Markman hearing has essentially bifurcated patent litigation. We no longer have a single, unified trial where a jury hears everything and decides the outcome.
It's split in two.
Exactly. We have a Markman hearing to define the words, and then, much later, a trial to apply those definitions. This bifurcated system duplicates efforts across the board. Technical experts have to be prepped, paid, and produced on two completely separate occasions. It monopolizes massive amounts of judicial time, bloats the litigation budgets for both the plaintiffs and the defendants, and drastically drags out the timeline from the initial filing to a final verdict.
It really grounds the entire topic for you as a listener. This procedural choke point proves that in the high-stakes world of patents and innovation, having a brilliant world-changing idea is literally only half the battle.
Only half.
The other half is surviving a gauntlet of federal judges and appellate courts to successfully defend the exact definition of the words you used to describe that idea. If you can't survive the Markman hearing, your patent might as well be blank paper.
This raises an important question, something for you to ponder long after this deep dive ends. The Markman framework was largely built around physical inventions, mechanical gears, chemical compounds, tangible things you can touch. But as we accelerate into an era dominated by abstract AI algorithms, neural networks, and machine learning models, how will federal judges trained in 18th century constitutional law, not 21st century computer science, adapt to interpreting the plain meaning of software code that even software engineers constantly debate? If the English language is so inherently ambiguous that even expert judges get their patent word definitions overturned by higher courts nearly a third of the time, are patents actually protecting the bold ideas of inventors, or are they just fueling an expensive high-stakes game of semantics for lawyers?